I'm glad you've joined us for another edition of the program that goes beyond headlines to dig into the heart of the matter. Now, today's conversation touches on a case that has sparked debate across the country. The sentencing of 28-year-old Akim Jimo to 3 years imprisonment for stealing yams worth 35,000 naira. Now, this story has raised pressing questions about justice, fairness, and proportionality in our legal system. And at the center of this discourse is none other than renowned human rights lawyer Femi Falana, SAN, who has voiced strong concerns about the ruling. Now, Falana's stance, as always, is rooted in the call for fairness, equity, and the consistent application of justice. He questions whether such a punishment is reasonable when compared with the scale of other crimes in our society, particularly when cases involving massive corruption and looting of billions often go unresolved or at best end with a slap on the wrist.
So, does Falana have a case? Is he raising a valid point about double standards in our justice system? Or is the law simply the law, no matter the value of the crime committed? This case takes us deeper into the heart of our justice system and forces us to reflect on some important questions. Does the punishment fit the crime? Are we treating petty theft with greater severity than white-collar crimes? What message does this send to the public, especially the poor and the vulnerable? And most importantly, is justice in Nigeria truly blind? Or does it sometimes see faces and figures, and it could also add plenty of zeros? Beyond the case of Akim Jimo, this discussion opens up broader issues about legal reform, the role of mercy in sentencing, and the need for a justice system that is not only lawful, but also just and humane. It challenges us to think about the balance between deterrence and compassion, about how society should respond to theft born out of desperation versus theft born out of sheer greed.
So to help us make sense of all of this, we are privileged to have with us this morning A.B. Robert Esquire, a seasoned legal practitioner, analyst, and advocate for justice. Thanks for joining us.
Thank you.
Now, with his wealth of legal knowledge and practical insight, he will help us assess Falana's position, examine the sentencing of Hakeem Jimo, and unpack what this case means for Nigeria's justice system at large. And of course, we want to hear from you, our listeners. Do you believe Hakeem's sentence was fair under the law? Or do you agree with Falana that this is an example of injustice and imbalance in our courts? Should the law be reformed to reflect both the letter and the spirit of justice? Don't go anywhere because it promises to be a powerful conversation. Of course, you know, this is Let's Talk Nigeria.
My drummer, them go show him face for grand fighter. Rich man with his money, we now they see their face for grand fighter. Tell me something I don't know why. Rich man go they all like we are. One man go they sound. Rich man go they all like we are. One man go they sound.
Ah, my goodness, we have to just spice up a little morning. This is Let's Talk Nigeria. I hope you've learned something from that song, right? It was reported. Now let's come back to our guests here in the studio. Well, Barrister AB, it was reported that Jimo Akim was convicted and sentenced on Wednesday last week by an Oshogbo Chief Magistrate Court after pleading guilty to a one-count charge of theft pressed against him. Now, when he was asked why he committed the act, Jimo told the court that he stole the 17 tubers of yam due to hunger and pleaded for leniency. But the presiding magistrate, Muiba Olatunji, sentenced Jimo to 3 years in prison with hard labor. Mark that. Hard labor. And without option of fine. So I ask Mr. Robert, from a legal standpoint, what does the law say about theft and sentencing in Nigeria? Was the 3 year imprisonment consistent with the law, and is that fair?
Okay, so let me start this way. There is a difference between law and morality. There is a difference between law and morality. In other words, there is a difference between what the law says and what the ordinary man ordinarily expects. So I'll give you a very good example. In the southern part of Nigeria, right, adultery is not a crime. In the northern part, where Sharia law also operates, it is. But morally, it is wrong to sleep with another man's wife if you're a married man. So if you do that, people will say, what you've done is very bad or it's very wrong, and all of that, but you've not committed any crime. So over here, morality will be a matter of morality, adultery will be a matter of morality, not a matter of the law. But over there, it will be a matter of the law and also a matter of morality. So let me start by putting it that way. So the question is this: did the man steal 12 tubers of yam from what we've seen?
17 tubers.
17 tubers, imagine, okay.
Well, 35,000 naira.
The answer is yes, he did. Was it right? No.
He pleaded for leniency.
We'll come to that. Let's just trash the issues one after the other. There are a lot of, dynamics to these whole things. So let's understand every part of it. What he did, was it right? The answer is no. No matter what, he has stolen, and that is wrong. Because if you just argue that, okay, on the ground of leniency, on the ground of whatever, then people will take it as an advantage to start stealing. There are people who even steal bread, sometimes 2 tray loaves of bread, not necessarily even because they have any good reason to steal. But if you look at it, you will say, it's bread now. Why do you punish this man because of bread? You understand? So, but then let's come to this man's case now, strictly speaking. I haven't treated the issue of morality and the law. The judge, was the judge or the magistrate right? Yes. If he has pleaded guilty to the offense, it means he committed it. The court sometimes takes into consideration other factors. There's what they call the mens rea. There's what they call the actus rea in criminal jurisprudence system. So what does that mean? The actus reus has to do with the act itself, the act of the commission of the crime. Then the mens rea has to do with the intention. So the court will analyze and say, okay, yes, the act was done, but did the person have the intention of committing that crime? And that is the reason why, for instance, in cases where somebody was intoxicated, not by his doing, and the person acted in a way, and the court may say, okay, or other defenses may then come in. He is dying. His children or our children, okay, are dying. And there is need to eat at that point in time. And maybe the person even asks, please give me a loaf of bread or give me bread to eat with my children. I beg, go away, get away. Who know you? I be your papa, I be your mama. And then the person, no option anymore. And then the person goes there, take a loaf of bread or 2, and then run away. And he's caught. You understand? And then he's asked, did you do it? Yes, I did it. Why did you do it? I was so hungry. My children are dying. I'm so hungry. No way. I've looked for a job. Nothing. There's not. And at that point in time, this is just the only means to just get to survive. The state of necessity. He has stolen. Yes. Wrong. Yes. That's morally. That's why I said morally wrong. Legally even wrong. But at that point in time, the court, the government, the person is the eye and ears of the government. So the person is seen. They are supposed to put on a human face to get back to the office of the Attorney General to say, there is this case, this particular case I'm handling. From the facts of this case, it's very clear this guy did what he did because of the circumstance. So I will recommend that we withdraw charges against that person. So in that case, the magistrate or the judge does not even need to go further to even sentence. The moment it is withdrawn, then the state will now take steps to see how they can possibly help that person, if it's to give him a job or whatever. Or the magistrate, in some circumstances, could even say, well, because of this, after a plea and all of that, and say, okay, punishment maybe. But again, there is a thing about punishment or sentencing. Sire Ekiomoye, I need to state this. You know, sentencing is a part of the criminal justice system. Yeah. Now, there are instances where the courts have what they call the option of an alternate sentencing. The option of alternate sentencing. And there are instances where the court is left with only what we call mandatory sentencing. So what do I mean? If the law says when you commit XYZ crime, the punishment is 3 years imprisonment, the court does not have any option than to sentence the person like that. But where the law says that, look, 3 years imprisonment or 5 years imprisonment with an option to pay fine, then the court has, that's what we call the alternate. The court can now say, okay, fine. Maybe sometimes the law may not state the particular amount to be paid. Then the court may say, okay, 50,000 naira pay, you go, or 10,000 naira, whatever the case may be. Sometimes you hear the law say, this offense, not more than 5 years imprisonment, which means that at that point in time, the law permits the court or the judge, so to say, to give a lesser, let's say 2 years, 1 year, as the case may be, and all of that. So, in summary, magistrates sometimes can be bound by the mandatory sentencing option or the alternate, depending on the nature of the offense. But in all cases, magistrates, judges are expected to put on a human face in giving their sentencing.
Okay, because while you were you were leading me to my next question, because we're saying that what sentencing guidelines exist under Nigerian law for non-violent property offenses, e.g., theft of food driven by hunger. In this man's case, is there any guideline at all?
There's really no guideline. Everything is up because first thing first, the judge it's not the judge's responsibility or the magistrate's responsibility to make a case for you. You have to make your case. The judge is an umpire. In fact, in Nigeria, we practice what we call the adversarial legal system, where the judge just sits as an umpire without necessarily interfering and allowing both parties, both on the proposing and the opposing side, the way they put it on their debate, right, to make their case. Then the court gives a judgment or ruling. The court is not expected to interfere. But in other jurisdictions, they practice what they call the inquisitorial system, where the judge sometimes even delve into the arena. So to say that, the judge is expected to make a case, no, that's not it. That's why I'm saying that most times this thing is a matter of the state and the person representing it. In the first place, this guy's case, I don't even know whether he had a legal representative. That's one issue, because sometimes what we get is just what is published on the media. We are not so sure. In fact, it makes the case even worse if that, in other words, there will be a better case for him on appeal if he does not even have a legal representative. But assuming he even does have in the first place, it's a matter of how his lawyer relates even with the state. And that's why sometimes even as lawyers, you have to be very, very understanding in managing cases like this. That's what they call the criminological perspective to criminal justice. Okay. Some people just have the ordinary criminal justice knowledge. Some other lawyers have what we call the criminological knowledge as an approach to criminal justice system. So what do I mean? By the criminal justice purely, we are just focused on sentencing. He has committed crime, sentencing. But a lawyer who has a criminological background looks at crime from a different perspective entirely. So what is the cause? So questions that a criminological lawyer will ask is, why did this person commit this crime? If, let's say, for instance, in a place, boys of about 18 to 15 years of, let's say 15 to 18 years of age are always taking hard substance in a particular community, and another community, we don't always see such things happen. what a criminological lawyer or a criminologist, so to say, would do is he would ask the question, not just gather boys taking substance, take them, punish them, and all of that. Why that is also done, which is also encouraged in some circumstances, a criminologist would then ask, why is it that people in this particular community are taking this substance, people in this other community are not taking? What really is the problem? So the criminologists then look at the cause of the crime, and then his belief is that if he's able to solve the problem leading to this crime, then crime will be combated. These are the criminologists actually look at crime. So if a criminologist, for instance, somebody, let's say in the ministry, for instance, as a lawyer, has the criminological knowledge to crime, the person's perspective will be different. And that's the reason why there will be need, for instance, to also engage, let's say, the ministry. Oh, my client this, my client that, but then these are the issues, these are the factors in place. Please, I would suggest, please, let's look for a way to settle this matter, or let's look for a way to put in a lawful prosecute, or look for a way to rehabilitate the person if there is need to do so. There is a penological perspective to criminology. There is also what we call the victimological perspective to criminology. Criminology is so broad. Those who understand how criminology work will understand what I'm saying. But I don't know whether this defense of state of necessity is really so applied here in Nigeria, whether it's even raised in the first place, I'm not aware. But in other jurisdictions, it actually applies. Places like Italy and all of that.
Okay, so Femi Falana, SEN, strongly criticized the judgment. Remember, the judgment is that he was sentenced to 3 years in prison with hard labor and without any option of fine. In your opinion, what exactly is Falana challenging? The sentence itself or the imbalance in how justice is applied in Nigeria?
Well, what we have currently is just a media report, and we have a challenge with that. If I had the opportunity probably of seeing the notice of appeal filed by Falana, then I would have commented better, because the notice of appeal that contains what they call the grounds of appeal gives you a better picture of where the lawyer is coming from. But as it is, I've not seen that, so I cannot say. But if we want to consider the media report, I think to a very large extent, Falana is basically attacking the imbalance. The issue of leniency is also there. Okay, I don't think that he's basically saying that the guy is not guilty of the offense. I've not seen anything like that. But just like you mentioned earlier at the preamble stage, that there are some factors the court ought to have considered. Why should somebody like that who stole, 17 tubers of yam? But some people will still argue, that, okay, even if you're hungry, why 17 tubers? No, these are issues. Why 17 tubers? If you are taking just one or two, right?
I think that's where the question of morality and intentions.
That's what I'm saying. 17 tubers. It's not about the thing you steal. That's not even the issue. Oh, bread. Like I said, then let's go back to the issue of, was the judge right? I think stealing 3 years or thereabout, yes, that's, I don't know, it should be even more than, I think the number of years is even more, if I'm not mistaken. I can't really remember the number of years in the Nigeria, the Bayelsa State Criminal Code or thereabout, but I think 3 years is actually, in fact, some magistrates, even some of them, I'm telling you the simple truth, sometimes the law may even say 7 years. They may even, at their own discretion, reduce it. And we've had instances where the matter even go to Court of Appeal, okay? And then the Court of Appeal will even say, the judge or the magistrate, you even brought the penalty down. It ought to be like this, is mandatory. We've seen instances like that, So who even knows whether the 3 years, but I can't really say particularly whether it's 3 years or 4 years or 5 years, as the case may be. But I understand the perspective of hard labor and all of that. Maybe because of the kind of thing, the nature of the item that is stolen. Some people will say, okay, our politicians they're stealing millions of naira.
That's exactly what we're coming from. And that's the reason for that song. That song. Remember the song we played earlier on?
The African China song. That's why we played it.
But then again, you can't still see. There is a way I see things, right? I know that yes, the politicians are stealing. Ordinarily, we ought to nail them and so on. But then, does that then justify stealing of whether it is bread, whether it is yam, because politicians are also stealing? Do we now start leaving all the people who steal bread and yam and everything, and even if it's 1,000, 10,000 naira, simply because, my brother, you know fully well that sometimes people have even been killed for stealing. People kill, you go to somebody's house, you are stealing 10,000. This guy is 35 or 10,000, and they kill somebody else because of 10,000. Kill my, you know it happens. Phone. Sometimes even the one we call China phone. Torchlight phone.
Yeah.
They kill because of that. Today we're having this conversation because this man said he stole because it is because he is hungry. Yeah. This is the reason why we're having this conversation.
Yeah, hunger.
If anger had not been mentioned, people will still talk though that it is yam, but like I said, it's not the item. That it's not really, it's the intent. So if truly this young man had done it because he was hungry, they will understand.
Maybe the court did not say that he was hungry.
These are the things.
Maybe the court was not convinced that he did it out of hunger.
These are the issues. I've not seen the judgment, So my perspective to the whole thing, I'm just treating all of the issues that are coming up from different perspectives. Yeah. At this point, I cannot say the judge or the magistrate was wrong in his or her sentencing. I can't say that because I've not seen the judgment to analyze it. There is a possibility that all of these defenses were brought up before the court analyzed all the evidence, and the court said, my brother, from the circumstance of the facts of the case, you understand, it is clear that you did not steal because you are hungry.
But Barrister, look at it. It is we're not justifying it. 72 bars worth 35,000 naira. All right here. Could there be other alternatives to imprisonment, such as community service or fines? 3 years. Look at the whole thing. Are there no other alternatives? Maybe that's exactly what Falana is saying here.
That's what I'm saying. You see, sometimes
especially community service.
See, we've seen instances where the court, when I mean the court, whether magistrate or judges, sentence put to community service. In Nigeria, we've seen it happen. Go online, you will see cases like that. Paul, yes. There are cases like that, yes. In fact, I've been in the magistrate court. I said the magistrate court, Federal High Court, then when I was working more like a private researcher. I've seen a judge, I don't want to mention his name, free people, defendants, cases of drug. They say, in fact, I heard the judge say, we've had instances where politicians do this. He said it even in open court. And for an offense like this, and he was even quizzing officers of the Nigerian Drug Law Enforcement Agency. Then what about rehabilitative measures? Are there no other measures and all of that? And he said he had to discharge them like that, on and on and on. You get? See my point? See where the problem lies. That's for that judge. Now, see where the problem lies, Aikiomoye. Like I mentioned, we have what we call mandatory sentence or punishment. Let's put it that way. Mandatory punishment. If the law says that anybody, who commits such an offense, let's say the law says 10 years imprisonment, that's the only thing mentioned, then the hands of the judge or the magistrate is tied. And at that time, or at that point in time, you would not say it is the fault of the magistrate or the judge.
So in this case, maybe it is
mandatory.
mandatory.
It is the fault of the law. That is the lawmakers. Judges don't interpret the air. They interpret document. And what do they interpret? They interpret the law. And the law is made by the lawmakers. So in Bayelsa State, you talk about rule. What? The House of Assembly.
House of Assembly members, yes.
You understand? But if the members of the House of Assembly, while making the law, state that, either so number of whatsoever, or with an option to pay fine, or they say not more than 3 years imprisonment, then the judge or the magistrate then have discretion. Or they say that rehabilitative sentencing, such as, let's say, community service or take to remand home and all. If those options are there, then the magistrate will have wider options to
So what you're saying is that there's the possibility that there were no options like this for this magistrate to have sentenced him in this manner.
Because we just want to find out what are the principles that governs the judges, final choice between custodial or non-custodial. Because end of the day, we're seeing that you should just allow them to just go with a fine or something, or community service.
If that's what I'm saying, that if the law that provides for that offense, you understand, the judge or the magistrate has discretion. Or they say not more than 3 years imprisonment, then the judge or the magistrate then have discretion. If that's what I'm saying, that if the law that provides for that offense, you understand, the judge or the magistrate has discretion. You understand? gives options, then the judge or the magistrate now has the discretion in the course of sentencing to take any of the options. That's my point.
But everything now, the box now stops with the lawmakers.
The law, it's the law. That's the problem. Now you only blame the magistrate or the judge when there are lenient options, and the judge or the magistrate fails to employ, exploit them. That is when you blame the judge.
So you're saying that there's a problem with the formulation or the law?
The law, yes. If I know, I mentioned the issue of even the victimological perspective of what they call a criminal justice. Remember I mentioned that.
Yes.
In fact, it's of late. It was when they add what they call the Administration of Criminal Justice Act that was not domesticated in Bayelsa State and other states. In fact, ours is the law, the Administration of Criminal Justice Law. It is this new species of law that was brought into the system that even started considering the issue.
No, we are not justifying it. But is it not also possible for the law, those who draft this law to look at, okay, fine, why don't you, return the 35,000 naira you stole, community service and all of that in order for it to be balanced? Because you do that to those who steal bigger money.
The elites.
Yes. The elites. The
not just the elites. So
bigger money.
Even cyber crimes.
Yeah.
A good number of those cases end up at the plea bargain stage.
And then the person goes free.
Yes. Yes. Not just that, but even again, there are cases too of simple offenses too, where we simply bargain roll out. If you even go online, like I said, it's not as if these things do not happen in Nigeria. Let's not get it wrong. These things happen. I think there was this case where somebody was found guilty of a crime, sentenced and all of that. And the court said your punishment is to do community service. You sweep the courtroom or something, wash these toilets and all of that. Yes, a day, and the person was cautioned, and that's that. It happened. Go online, you will see cases.
That's fair enough.
It's not as if, let's not make it look as if our judges and our magistrates are not exploring these options. My point again is this, IQ Moye. It is an issue of the law, the wording of the law. If what the punishment stated there is mandatory for the magistrate or the judge has no option.
But
However, we still have instances where judges, that's what they call judicial activism, but some will even call it judicial rascality, where the judge would stubbornly on his own say, well, even though the law says this is mandatory, I would just do what I want to do. Okay, the court can just say, this crime, he's guilty, but let's give him community service.
Yeah.
Yes, we see it happen.
That's human face.
You see it as human face. But you see that judge. See, there is a way this system operates. You may not understand.
It seems like the law is harder on the poor
No, it's not a matter of the poor.
Because that's what Nigerians are saying. This whole thing.
It's not a matter of the poor.
Because this man is, he's a nobody, and so it's going to be coming down hard on him.
It happens
real
to be
hard.
an auto mechanic.
The problem is
An auto mechanic. Yes.
The problem is not. So when you make it sound as if the law is hard, you then make it sound as if in the body of the law stated that if a poor person is caught, punish him hard. Then when a rich man is caught, don't punish him.
Why is it like that? Because in general, but Nigerians are saying that, look, it happens so often to the rich, down to the poor.
There are also rich people in this country that have been convicted of crime.
How many? How often?
You may say that yes. You may say that yes. There are a lot of politics playing now. So we agree.
Why can't politics play out in this particular one?
We agree.
Why can't politics play out in this particular one?
See. The question is as if now I'm supporting what it.
No, you're not supporting. I'm not trying to say it. We're trying to be very.
I've subjected that.
Yes,
because everybody just wants to wonder. You brought up a very, very sensitive issue that has to do with the lawmakers and our constitution. What is being provided for is all that the judges are interpreting.
Exactly.
So that means if we want to do anything fundamentally, we have to go back to this other side to correct it from the foundation.
Yes, that's what I'm talking about. There is, in fact, some of our, if you go to our criminal code law, I have to be very. I don't know when last they even amended some of those provisions. So old. Some offenses.
Now you're talking so old.
So old.
Now you're
That's
talking.
That's what I'm saying. So the bulk of the. Sometimes people get it wrong. They think that magistrates are doing this, judges are doing this. It is not their fault. the court is there. For instance, I'm appointed as a judge or as a magistrate. My job is to interpret the law. You bring it before me, I look at the law and I say, okay, from what I've seen, this is the law. Oh, evidence before me, this. Whether you stole because it is for hunger, it's not for hunger. Oh, the law is the law.
You know what? Let's use the next 15 minutes dedicated solely to our listeners to calling and make their contributions and ask questions to the lawyer here. 0707 747 1522 0912 000 1975. You can head on Facebook as well. We're streaming live. Drop your messages. They will read out the messages to our listening pleasure. Let's get the first. Make it very brief. I'll be very strict. Good morning. Thanks for joining us.
Good morning. My name is Saibano Ambakdermo. I'm calling from Onopa community.
Okay, please go ahead.
From what I read in the newspaper, that he was an ex-convict. The question we should ask, when he left prison, did his members of his family, the community, assist him to become gainfully employed, or they just pushed him away and he became desperate to take care of himself? That is one of the questions we should ask. Secondly, I don't know whether the judge also asked this question, that when you left prison, what happened to you? Thank you.
Thank you. I like that. I like the brevity of the question. Let's take more calls and then we will come to Barrister A.B. Robert. Hello. Good morning.
Hello. Good morning.
Good morning.
Yes, my name is A.Y. I'm calling from Akinsa.
Okay, please go ahead.
Yes. No, for me, the way I look at this matter and the way the man in the studio was affecting the law and its consequences. You see, I'm thinking that for a senior advocate, caliber of Femi Falana and other activists, in particular, that a particular matter, that maximum sentence given. It means there is something that they are saying, because as a well-experienced advocate of the Federal Republic of Nigeria, don't you think that magistrate, with the explanation of this defense, don't you think the judicial powers as a judge, based on maybe sentiment, nobody is out there, maybe no, because it's and he doesn't have the money to hire a lawyer to defend. That is why no matter his convictions, the judge doesn't want to look at it. It's now we want to talk about this matter. The case of Ozuzo, the prominent politician and the governor, was once found guilty, and they brought in a technical and a political defense to Office of Kano that the judge has already been transferred. Don't the judge know that if a particular judge has been handling it,
please round off.
He has been transferred.
Please round off. Thank you.
In essence, that he is a human rights lawyer that is in the studio. Don't you think before
there would have been an option of fine? Because looking at the magnitude of what the guy stole, of year amounting to 35,000 naira, is too small to send that guy for 3 years imprisonment. It is too small. That one is too small. Look at what our people are taking every day. How many of them were convicted? Look at former governor of Kogi State, Yaya Bello, going scot free. So many of them. How many of them were convicted? They have issues here and there in the court. No one is on trial. At the end, the thing will just die like that. The other 76% of year amounting to 35,000. At least they would have given him maybe 2 months or 3 months, or at most maybe an option of fine. Then if he did not meet up to pay the fine, then he should go for that. But a whole 3 years with hard labor. My My brother, it's too much. It's too much. Let me be sincere. Let's go. It's too much. To me, it's too much. Thank you.
Thank you, Pastor Len White. That's it. I think that's the sentiments of many Nigerians, though. Let's get this call. Hello, good morning. Quickly, make it very brief. I appreciate you. Good morning.
Okay, good morning. We can hear you. Please go ahead quickly.
Yeah, greeting once more. And thank you. I also give the resource person in the house. This is from, you see, most times when you want to react, you always want to counter the resource man in the house from the realistic perspective. And what do I mean by that? You see, the law we practice in this part of the world is as if the law is only for the poor man. You see, if you permit me to use the elite as an example, you see somebody that has been invited by the anti-corrupt, the relevant authorities watching our financial crimes and whatever. They'll be invited. Some will be even convicted. But the next time you see them in an appointment handling a public position in this same country, why is it so? Why is it that the law is only for the poor man? And there will not be tag attached to such persons for being an ex-convict. But it's for the poor man, the laws will stand this way. Why is it so? Which way in Nigeria? I think we have to amend our ways. So you will not blame Falana. You see somebody that has committed a very menial, I know, like a legal practitioner say, a crime is a crime. It is even a cup of curry. It's an equivalent to 1 billion. A crime is a crime. No doubt about that. But the truth has to be told that we should face things realistically and look at it from the common man point of view. Thank you this morning.
Thank you. We appreciate you.
Well stated.
Yes, well stated. Good morning.
Good morning.
Good morning. Welcome to the show. Hello. Well, we lost that call again. Maybe call back.
Kindly call back.
Call back. Good morning.
Hello.
Yeah,
Morning.
good morning.
My name is Elfrida. They call from Amrata.
Oh, Elfrida. Yes,
Elfrida.
please go ahead.
I want to ask the lawyer where they there. Another way, no, they to punish that young man. Why did they say this law, and I let the poor people they owe? Okay, at the end when the lawyer they talk one or two things. Okay, make it effort tell us how many of the politicians we don't see for this big money. How many of them the law don't own? How many of them that arrest? Make the lawyer make it effort explain. How many of the politicians don't see? When they say their name don't come and say we don't hear say they don't owe this politician we don't see this money. Make it help me explain. And another way no day to punish that young man. Now we can get to talk. Make it answer the question when I ask.
Hello. Thank you very much. You know, the question is that with hard labor.
That's the thing. I think that's the concern for everybody.
Let's take this very last one before you respond. Good morning.
Good morning.
Good morning, sir.
Good morning.
Your name, where are you calling us from?
My name is Thomas. I'm calling from Tonga community, sir.
Okay, Thomas. Please go ahead.
First of all, I want to appreciate the barrister that is there. My suggestion is that what I have in mind is that, why is it that in this our country now, the law is just like only for the poor people and the rich people, most especially the politicians. Me, I'm a political scientist. Politicians, upon all the money they are looting, the embezzlement, everything, the billions, they will be taken to the prison with labor. Person that it's not that what the person did is good, but they can just give him a fine of maybe 50,000 or this is just release him. But all those politicians, all these things, the security, the handle, the people who graduate from school, there's no this thing. They're not that doing the law as the legislators, and at the end of the day, the law that they do, the law affect themselves to the common man. They are stupid. So what I'm saying, I don't really like it because that is an intimidation. Thank you.
Okay, so you get better my mind the way you use words on radio.
Please,
we don't support that.
Very civil expressing yourself.
Mm-hmm.
You can do it in the best of ways.
Yeah, no, we don't accept such words like stupid and all of that. We don't accept that. Barrister, calm down. You answer the questions. You know, we've spoken a lot.
Piling up.
No, they're piling up. Let the pile up. You summarize everything. Hello, good morning. Good morning. Good morning.
Good morning, Barrister. Good morning.
Good morning.
The 17 tubers of year to pay how much? 3 years in prison.
Yeah, with 3 years with hard labor.
This kind of judgment. Though I'm not a lawyer. I've been listening to the lawyer there, but is it not too much? Is the punishment not just too much? 3 years in prison for stealing 35,000 naira. Can't they review the judgment? I thought maybe they would say pay maybe 200,000 or pay 100,000 and get a B, and maybe with hard labor for maybe 1 week or 2 weeks. To me, this punishment is too much. That is sir. Can't you fight for the guy? Or is it too late?
Interesting.
AB, thank you. Thank you so much, AB. So let's the barrister answer the questions now. I mean, no more calls again. We're not taking any more calls.
Yeah, because of time.
Talk as for the next 2 minutes or 3 minutes, perhaps.
Okay.
Freely, yeah.
Okay, so first thing first, let me clarify. I am not saying that the judge is right. Neither am I saying the judge is wrong. One, I have not seen the judgment. What we have seen is just media reports. So I cannot even give a fair analysis of the case 100% until I see the judgment, see the case of both parties, see the evidence presented before the court, then see the reasoning of the court to know why the court came to its conclusion. All of us are just talking based on media reports. Nobody has seen that judgment. That is one. However, I am also stating that, yes, there are instances where the court may consider what we call the state of necessity. I mentioned that earlier. Yeah. So it's not as if I'm supporting the magistrate or the judge. I said, yes, the court can be lenient. At the same time, also stating that, look, there are instances where we still have the hands of the judges or the magistrate tied. You understand? Where they have no other option than to what? Give the punishment stated by the law, because it is mandatory. And in that instance, it is not the fault of the what? Of the judge or the magistrate. I need to state that so that we will know. So that we will not just blame the magistrate or the judge. And I also mentioned that there are instances where judges even tend to be lenient in their sentencing, even when there is a mandatory punishment. And when it goes on appeal, the Court of Appeal justices lambast the magistrate or the judge of the High Court. This is what the law stated. You are doing something else. Some will call it what I call judicial activism. Others will call it judicial rascality, because we're supposed to follow what we call judicial precedent. So let's not entirely blame the magistrate or the judge until we see that judgment to read and analyze and also appreciate it. That's on the one hand. Secondly, Saiki, I also mentioned, let's not just blame the judges or the magistrate. We need to also blame the lawmakers, because it is high time the lawmakers start reviewing their laws so that they can start accommodating these alternate sentencing and punishments. That's my recommendation. Somebody mentioned whether I should have come out to defend the guy. I'm not his lawyer. I can speak as a human rights activist to look at the laws and all of that, except the person briefs me to do the job. So I don't. It's unethical to even say you want to start defending somebody except the person comes out. So you already, Falana is taking up the matter, and I believe he will do justice to the case. That's on the one hand. So I'm not in support or against the guy. I'm just treating the laws the way they are. Somebody asked a question concerning whether the judiciary, whether they have an arm or something. Basically, we should understand that the work of the judiciary is not to make law. Let me make that very clear. Are we together, please? Yes. It is not the work of the judiciary to make the law. It is rather the work of the judiciary to interpret the law. So we have stakeholders and advocates and all of that out there in the society who then are supposed to take advantage of the instrumentality of lobbying. We have lobbyists to lobby and all of that, and then see how the judiciary, the legislature can make law that would. So that's that. So I'm not aware of any specific arm in the judiciary. Then there is another very interesting thing, Saiki, that somebody mentioned. Somebody asked whether is the law only for the poor. Ordinarily ought not to be so, but unfortunately we see something different happening in our society. But let me also ask this question again back to the people. Is there any system of justice that we know, though not legally allowed or permitted, but exists in our society that is in the hand of the poor man? The answer is yes. What is that system of justice? Jungle justice. It has no legal backing. It is illegal. But that's the system of justice that the poor people operate. Let me also ask the poor people now, because they make it look as if they are saints. Is jungle justice only for the poor or for the rich and the poor? Because people are asking whether the law is only for the poor or the rich. Those poor people who also implement jungle justice, how many times have they lashed and maybe killed the politicians who steal? Most of the people who are killed by the same poor people are what? Poor people. People who steal yam, who steal 1,000 naira, and all, they catch them in the market, they kill them. So are the poor people not also guilty? Because even the justice system that they implement, which is not backed by law, too, we see it only implemented on the poor. Okay. So we are all guilty.
All right, we're all guilty. Yeah, but thank you. No, I mean that's all. I appreciate you. Okay, drop this last one. Do you have no time anymore?
Just two things. Lastly, please.
Just 60 seconds.
The first person who talked about what I call recidivism, which is somebody that's committed a crime, been convicted, going back to commit that same crime again. A lot of factors need to be taken into consideration. I can't speak on that, whether all of those factors are brought before the court. Lastly, for the Uzo Kalo case, very technical case. That's the last point I want to make. But we need to understand something. The Administration of Criminal Justice Act states that, look, when a judge of the High Court was handling a matter and the person is elevated to the Court of Appeal, and why the person is elevated is here to conclude that case, that where a permission is sought from, I think, the president of the Court of Appeal, all right, that permission can be given, fiat can be given for the person to go back and handle the matter. That's what happened in Uzo Kalo's case. When the matter went to the Supreme Court, the Supreme Court said no, that is wrong by law. The moment you are elevated, ordinarily matter is expected to start de novo also, so that faulted the punishment, the system, so to say. So it was not the case of, I won't say it's really the fault of the system and all of that. I think it's a matter of interpretation of law and so on. So there are many dynamics to this issue, sir. Time is not really there for me to even trash out on the issue. Thank you, sir.
Thank you very much, Barrister A.B. Roberts, for coming on the show this morning. We do appreciate you. Thank you very, very much. Paul.
Thank you.
Yeah, when it comes to this, the case of Jimo Akim is not just about the yam. It's not. It's about the urgent need for sentencing reform in Nigeria. Until we build a justice system that balances punishment with compassion and rehabilitation, we'll continue to waste lives and resources while ignoring the real thieves of our collective commonwealth as a nation. My name is Paul Oblomogbasa. Let's rethink and rebuild Nigeria. That will be fairness and equity for all.
And from me, the case of Hakim Jimo is more than just a legal story. It is a mirror reflecting the state of justice in Nigeria. It forces us to question whether our laws protect the vulnerable or punish them more harshly than the powerful. Now, Fowler's stance reminds us that true justice must balance legality with humanity, punishment with compassion, and deterrence with fairness. Now, if the law is to command respect, it must not only be seen to punish, but also to heal and protect. Ultimately, justice is not about strength, but about equity, and Nigeria must embrace that balance. Justice without compassion is injustice in disguise. Until next time, this is Let's Talk Nigeria. Let's keep the conversation and the dialogue alive. I am Moya Stephen.